and welcome to the Honorable Justice Charles D. Gonthier Memorial Lectures. My name is Chris Weiserick, and I will be serving as one of your moderators here today.
Hello, and welcome to all of our participants. My name is Tejas Rao. I'm Senior Manager with the Center for International Sustainable Development Law and PhD researcher here at the University of Cambridge. Together with my co-moderator, it is a pleasure to introduce the chairs of our 2024 Gonthier Memorial Lectures, Professor Marie-Claire Cordonier Segger, Chair in Sustainable Development Law and Policy at the University of Cambridge, and CISDL Senior Director, is a laureate of the prestigious His Excellency Judge Christopher Gregory Weeramantry International Justice Award and was elected Fellow of the Royal Society of Canada in 2022. Honorable Elizabeth Maruma Mrema, Assistant Secretary General of the United Nations and Deputy Executive Director of the United Nations Environment Programme, recently also served as Executive Secretary of the Convention on Biological Diversity and is laureate of both the Q International Award and the His Excellency Judge Christopher Gregory Weeramantry International Justice Award. Professor Marie-Claire Cordonier Segger and Honorable Elizabeth Maruma Mrema, thank you very much for chairing, and over to you.
Welcome to the 2024 Honorable Justice Charles D. Gonthier Memorial Lectures and His Excellency Judge C.G. Weeramantry International Justice Awards. We are honored that you could join us for this always monumental occasion, featuring addresses by world-leading scholars and jurists to honor the legacy of two very deeply missed and appreciated early and eminent mentors and pioneers in international law on sustainable development. As you know from the theme of this conference, the natural world is in crisis. We face a climate emergency. We face a biodiversity emergency. Natural resources are being degraded at an alarming rate. These terrible trends are a global sustainability and justice challenge of our century. It's because of the justice focus that we're here today. Millions of nature-based communities and livelihoods, entire cultures that could be sustainable are being undermined and impacted, affecting both current and future generations. And it's also a justice crisis because of our grave common concern of millions of other species, 8.7 million, according to recent studies, with 69% in decline and 41,000 threatened with extinctions, alongside the oceans, climate, and other natural systems we all depend on. We need new nature-positive directions and pathways for continents, countries, and communities. And the Sustainable Development Goals, the 17 goals and 169 targets that we're here to celebrate today, so many of them depend on nature. Although laws are written by people, for people. So that is why we have focused this symposium, the third in a series, on international law and governance and how it can become part of the solution. And that is why we are deeply, deeply honored to be joined by so many of the leaders in this field to celebrate the legacy of two extraordinary mentors and to turn the best of our minds toward the solutions that are needed. I'm going to turn now to the Honorable Elizabeth Mrema to simply say hello, and then we will move straight forward into the lecturers.
And that is simple from me. Good evening to all of you from Nairobi. And indeed, it's a pleasure to see you all and really ready to listen to the inspiring messages on the topic of this year. Thank you very much.
Absolutely, and welcome. And thank you for all of your effort in chairing this symposium with us today. It has been a pleasure to be collaborating with you. We will begin with the Honorable Justice Charles D. Gonthier Memorial Lectures. This lecture series was initiated to celebrate and honor the legacy of Supreme Court Justice Charles D. Gonthier, recognizing the importance of his work for several generations of Canadian and international jurists in promoting responsibility, sustainability, and justice. Internationally renowned speakers, carefully selected by a committee of experts, are invited to provide a distinguished lecture every 2 years, co-hosted by McGill and many other institutions with which he had a strong connection, highlighting matters of international, civil, and constitutional law related to justice and sustainable development. It is my pleasure now to introduce the Honorable Judge Sebastien Grammond and Dean Robert Leckey of McGill Faculty of Law to open and welcome. Please, Judge Sebastien.
Thank you. So I have the privilege of welcoming you to the 2024 edition of the Charles Gonthier Memorial Lectures. Charles Gonthier was a renowned jurist, lawyer, and judge. He was a justice of the Supreme Court of Canada from 1989 to 2003. He was a man of wisdom, rigor, and vision. He truly mastered a broad range of legal areas, from civil law to constitutional law. He knew that the law could not be divorced from the broader moral and ethical imperatives governing human conduct. I had the occasion to meet him when I was a law clerk at the Supreme Court many years ago. I remember a complex case that none of us knew what to do with. And when his draft judgment was circulated, it was really a masterclass in legal reasoning. I was not alone to admire Justice Gonthier's wisdom and legal skill. He is remembered as one of Canada's most respected judges. As recently as last week, when dealing with a complex constitutional law issue, the Supreme Court basically reaffirmed what Justice Gonthier had written in a judgment 20 years ago. It is thus fitting that these biennial lectures celebrate Justice Gonthier's legacy. Every time the speakers remind us how he can be a source of inspiration for using law to address the most pressing issues of our times. Thank you.
Thank you. And thank you also. Speaking of master wisdom, we have been reading your judgments from the federal court, Sebastien, and we deeply appreciate the thinking.
It's not close to Justice Gonthier.
Well, your expertise is very, very notable, particularly in areas of Indigenous law, as well as constitutional and comparative law, and it's deeply appreciated. We're now going to turn to a video address from Dean Robert Leckey, my former classmate at McGill, who is quite understandably away this week, but has filmed a brief introduction. All right, I think we will try again to play his video at the very end. But for now, we will press onward. There's always at least one technical problem, and let's hope that was the one. I would like to especially thank Judge Grammond for being here in person so that we did not have that problem. And I will thank Dean Leckey for the sentiments that he did convey in the video, welcoming us and honoring the connection of Judge Gonthier to our faculty. I'm now very, very happy to introduce a special speaker who is helping us to open this biennial event. Justice Mahmud Jamal was appointed to the Supreme Court of Canada in 2021. Prior to his appointment, he was a judge of the Ontario Court of Appeal and had a distinguished career as a litigator, specializing in constitutional law, administrative law, and commercial litigation. He also served as director of the Canadian Civil Liberties Association, the Advocate Society, and the Oslo Society for Canadian Legal History, earning many distinguished honors. I think one of the main reasons that he, however, has been invited by the Supreme Court to be our speaker today is that he also served, of course, as a former law clerk to Judge Gonthier at the Supreme Court of Canada. So, Honorable Justice Mahmud Jamal, the floor is yours.
Thank you very much, Marie-Claire. Bonjour, je suis très honoré d'être parmi vous et de vous partager quelques brèves remarques avant la discussion importante de cet après-midi. These memorial lectures touch on topics that are among the defining challenges of our times: climate change, sustainability, and our common future in a warming world. These issues transcend national borders, demanding courage, creativity, and collective action. As many of you know, Justice Charles Gonthier was no stranger to these values, nor to the important challenges posed by climate change and environmental protection. After retiring from the Supreme Court of Canada, Justice Gonthier increasingly leaned into these passions, becoming chair of the Board of Governors of the Centre for International Sustainable Development Law at McGill University. Through this role, he recognized the fundamental importance of a healthy and resilient environment to human rights, justice, and the integrity of both people and planet. Sans aucun doute, les défis posés par ces questions sont complexes, et face à eux, on peut se sentir impuissante. Il y a pourtant de nombreuses raisons pour nous faire espérer. In recent months, for example, the International Tribunal for the Law of the Sea delivered a landmark decision recognizing that greenhouse gas emissions absorbed by the oceans are a form of marine pollution. This ruling not only underscores the urgency of climate change, but importantly affirms its centrality in contemporary legal discourse. The role of international law in combating climate change is something that all courts, including the Supreme Court of Canada, will have to address with increasing frequency. Jurists around the world will no doubt look to the Tribunal's precedent-setting decision for guidance in the years to come. As well, among my reasons for being hopeful about what lies ahead are the advocacy and research that you are all engaged in. I'm delighted to see such diverse issues covered in today's program, from Indigenous rights and intergenerational justice to the role of international law in advancing biodiversity and the Sustainable Development Goals. Your work gives me great encouragement that we may yet be able to rise to the occasion and face these pressing matters head on. I am very enthusiastic about this year's memorial lectures, and I'm quite certain that Justice Gonthier would have been as well. Ce fut un privilège de m'adresser à vous et je vous souhaite un agréable après-midi.
Thank you so much, Honorable Justice Mahmud Jamal, for your eloquent remarks. We will try one more time to hear from Dean Robert Leckey, and if not, we're going to go straight to the main act of our two selected Gonthier lecturers for this year.
Greetings from the Dean's Office at the McGill Faculty of Law. I'm delighted to have an occasion to welcome you to this Charles Gonthier lecture. The late Justice Gonthier was a holder of 2 McGill Law degrees, BCL 1951, and then an honorary doctorate conferred in 1990. And we're always so proud to see that his legacy is carried forward by this event. Some people think of Justice Gonthier as having been a relatively conservative jurist, and yet some of the values that he espoused and that are recognized in connection with this lecture show that in other ways he was ahead of his time. And so his commitment to sustainability, to community, to equality are more current today than ever. And I'm so pleased to see that legacy carried forward in today's event. I wish you a successful lecture and gathering, and look forward to continuing honoring Charles Gonthier in the years to come. Many thanks.
I will thank Dean Leckey, Robert, for his kind remarks and welcome. And I will especially thank Tejas for being a miracle worker. You are a star. Thank you. I'm now very, very pleased, remembering in 2002, the World Summit for Sustainable Development and the Global Judges Symposium that the United Nations Environment Program organized at that time with Judge Gonthier and Justice several justices actually, but I remember in particular being welcomed by Bishop Desmond Tutu and Justice Albie Sachs in South Africa as part of the World Summit to discuss the civil law and the common law and how they can be put to the service of the global environment. I think Elizabeth might have been there with us, together with Bakari Kante and Lal Kurupu Surya and others. It was an incredible time. And I think when I remember his contributions at the global level, he was indeed a visionary. He was very clear what the law can do and where the state of Canadian law was, and he stuck within those limits in his judgments. But he had an idea of society which challenges us all and continues to challenge us today, and of solidarity, what he called fraternity in his way, which meant our joint responsibility. The two people that I'm introducing today, of course, embody that spirit and that generosity of understanding, indeed that wisdom, and it is a privilege to know them both. Christina for many years, and Kathy-Ann as a new friend. Professor Christina Voigt is a renowned expert in international environmental law and a professor at the University of Oslo. She served as a legal advisor to the Norwegian Ministry of Climate and Environment and has been a key figure in the development of international climate architecture, along with authoring numerous academic articles, a monograph, and several edited book collections, including one that we're finishing right now with 32 chapters that have come back to copy edit just recently. the Routledge Handbook on Climate Law and Governance, which Christina and I are quite determined to call Courage, Contributions, and Compliance. She is also the chair of the IUCN's World Commission on Environmental Law, which is one of the organizations I respect most in this field, and serves as principal legal advisor in the UN climate negotiations, including the 2015 Paris Agreement, where she has served as co-chair of the Paris Agreement Implementation and Compliance Committee. So welcome, Christina, and congratulations on being selected as the Gonthier Lecturer for this biennial. I'm also going to introduce the other lecturer, Dr. Kathy-Ann Brown, a judge of the International Tribunal for the Law of the Sea. She previously served as permanent representative of Jamaica to the International Seabed Authority and as Deputy Solicitor General of Jamaica, in addition to numerous other high-profile roles in an extremely honorable, long and varied career as a lawyer, such as serving as the Chief Technical Advisor to the Prime Minister of Jamaica in one of her roles. In 2019, in recognition of her significant contributions to international law, Dr. Brown was inducted into the Hall of Eminent International Caribbean Jurists. I understand that we will hear first from her and then second from Christina. Please, Justice Kathy-Ann Brown, the floor is yours.
Thank you for the invitation to be here with you at the Honorable Justice Gonthier Memorial Lectures. The chosen topic of this year's symposium allows me to address one of my preoccupations, that is raising awareness of the role of the law of the sea in protecting and preserving the oceans, which play a crucial role in maintaining nature's ecological balance and serve as a source of livelihood for vulnerable communities around the world and small island developing states. The Sustainable Development Goals are for many mere aspirations. SDG targets are seldom linked with states' obligations. Often SDG targets provide a minimalist description of the responsibilities of states as collective trustees of the natural world. I refer in particular to SDG 14, commonly referred to as life below water. The natural world, as widely conceptualized, is viewed in juxtaposition with humans or human creations. The perception of humans as distinct from the natural world has influenced our approach to sustainable development and goal setting in the formulation of SDG targets. The Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services is in its 2022 assessment report suggests that achieving the 2030 Agenda for Sustainable Development and the 2050 Vision for Biodiversity depends on system-wide transformative change that incorporates the diverse values of nature. I intend to address two issues. Firstly, the principle of sustainable development, which informs the Sustainable Development Goals, and secondly, the SDG Goal 14, in light of the obligations of states under the 1982 UN Convention of the Law of the Sea, which I refer to as the Montego Bay Convention, or UNCLOS, briefly referring also to the 2022 Global Biodiversity Framework, the GBF, which contributes to the achievement of Agenda 2030 and resets global ambitions for the natural world. Sustainable development is commonly defined as meeting the needs of the present without compromising the ability of future generations to meet their own needs. It is unclear how the principle of sustainable development balances the scales of daily justice in weighing the desire for economic growth with the protection of the environment. Judge Wirantsuri, in his separate opinion in the Gabsi-Kobo-Nagimaras case, recognized the normative value of the concept of sustainable development, tied to the principles of reconciliation and tolerance in resolving the needs of development and the necessity to protect the environment. The right to development, he observed, does not exist in the absolute sense, but is always relative to its tolerance by the environment. Justice Gonthier expressed a similar theme in his writings. He observed that sustainable development law seeks to bring together, rationalize, reconcile, and harmonize the various strands of the law. The Constitution of the Oceans, that is the Montego Bay Convention, provides the governance framework applicable to life below water. That's the subject of SDG 14. It adopts a sectoral approach supported by the principle of due regard, which requires tolerance and reconciliation. There are no rights without obligations, nor freedoms without restrictions. And this is complemented by the duty of cooperation, which is a fundamental principle of international law and UNCLOS, Part 12 on the protection and preservation of the marine environment. UNCLOS Article 193 reflects the principle of sustainable development. It places a constraint upon states' rights to exploit natural resources, which may only be pursued in accordance with the obligation to protect and preserve the marine environment. This obligation is one of due diligence. As indicated in the ITLA's Climate Advisory Opinion, the implementation of this due diligence obligation may vary according to states' capabilities and available resources. Such implementation requires a state with greater capabilities and sufficient resources to do more than a state not so well placed. Nonetheless, implementing the obligation of due diligence requires even the latter state to do whatever it can in accordance with its capabilities and available resources. To speak of sustainable development goals, therefore, suggests a reconciliation of competing economic and environmental objectives in a manner that promotes both intra- and intergenerational equity. The recognition of common but differentiated responsibilities releases no state from the obligation to protect and preserve the marine environment. This is limited only by its capabilities and available resources. SDG Goal 14 in particular directs us to conserve and sustainably use the oceans, seas, and marine resources for sustainable development. The 2022 assessment report of the Intergovernmental Panel on Climate Change states that local to international decision-making bodies have assigned the lowest priority to SDG 14. This is particularly troubling, as the report also states with high confidence that the impacts of climate change on the oceans and coastal ecosystems threaten the achievement of all the UN SDGs by 2030. The adverse changes in the ecological balance of the marine environment are not solely attributable to climate change, but are widely acknowledged to have an anthropogenic source. SDG Target 14C addresses one of the means of achieving Goal 14, that is by implementing international law as reflected in UNCLOS, which provides the legal framework for the conservation and sustainable use of oceans and their resources. The focus here is on conservation and sustainable use, as opposed to the broader obligation under the Montego Bay Convention to protect and preserve the marine environment. The living resources of the sea and marine life are part of the marine environment. In the Climate Advisory Opinion, ITLAS expressed the view that the obligation to preserve the marine environment applies in all maritime areas and entails maintaining ecosystem health and the natural balance of the marine environment. This includes restoring the marine environment where the process of reversing degraded ecosystems is necessary in order to regain ecological balance. This understanding informs the approach to be taken in implementing SDG 14. SDG 14 targets 1 through 14.4 are somewhat aligned with states' obligations under the Montego Bay Convention, but go no further. They are certainly not aspirational in the sense of reaching for the stars. Rather, they are a testimony to the continuing implementation deficit in fulfilling the obligations that has resulted in the accelerated degradation of the ocean environment. SDG Target 14.4, as an example, to take this as an example, this addresses sustainable fishing with references to the maximum sustainable yield, but omits important qualifiers found in the Montego Bay Convention, Articles 61 and 119. In the Climate Advisory Opinion, ITLAS expressed the view that the implementation of conservation measures under Articles 61 and 119 entails the application of the precautionary approach in addition to the ecosystem approach. This position is mirrored in the Fish Stocks Agreement, but not in SDG 14. The ITLAS Advisory Opinion also addresses ocean acidification, which finds expression in SDG Target 14.3. The obligation stated in UNCLOS Article 192 to protect and preserve the marine environment can be invoked to combat any form of degradation of the marine environment, including ocean warming, sea level rise, and ocean acidification. This obligation is one of due diligence. The standard of due diligence is stringent, given the high risk of serious and irreversible harm to the marine environment from climate change impacts and ocean acidification. SDG Target 14.5, on the other hand, addresses an issue on which the UNCLOS is largely silent. Target 14.5 partially affirms ACHI Biodiversity Target 11 on conserving at least 10% of coastal and marine areas. The GBF takes forward the work done at ACHI. Here, emphasis is placed not only on the quantity of areas, but also the quality of governance. The importance of this is demonstrated in the IPCC 2022 report, which suggests that the placement of MPAs has been driven more often by political expediency than by managing key drivers of biodiversity loss or climate-induced drivers. The GBF, which is presented as a contribution to the achievement of the 2030 agenda, seeks to respond to numerous scientific assessments, raising the alarm on the worldwide deterioration of biodiversity at rates unprecedented in human history. Comparisons have been made between the approach adopted in the GBF and the Paris Agreement. The debate over the legal status of the GBF is less important in my view than the consensus on the global ambition defined through its targets as identifying the standard by which reasonable conduct may be evaluated and judged, taking into account national circumstances. The GBF resets the discussion on the natural world and the law and complements the SDG's principal focus on human development. In closing, I would note that Justice Gonthier advanced sustainable development as part of global justice. And so, remembering the words of the 1987 Brundtland Report, a world in which poverty and inequity are endemic will always be prone to ecological and other crises. I hope I didn't extend my discussion too long, but thank you for your time.
Thank you very much for that thought-provoking and extensively researched lecture, which we deeply appreciate. I'd only wish we had an entire day to hear some of your thinking behind it. I'm going to turn directly to Professor Christina Voigt, who is our second Gonthier lecturer for this biennial.
Thank you, Marie-Claire. First of all, I'd like to thank the chairs of this wonderful symposium, the natural world, the SDGs, and the law, Professor Marie-Claire Cordonier Segger and Elizabeth Maruma Mrema, as well as the partnering organizations for this very kind invitation to give one of the 2024 Gonthier Memorial Lectures. It's a great honor, it's a great privilege, and it's also a great joy. And second, I would like to thank and congratulate Honorable Judge Dr. Kathy Ann Brown for her wonderful and insightful lecture and for her generosity in sharing her experience and wisdom with us, even though it makes an impossible act for me to follow. The topic of my lecture is promoting the rule of law in taking urgent action on climate change, the interplay of SDGs 13 and 16. And I'll make 3 points. First, that SDG 13, the need to take urgent action to combat climate change, is not a goal, it is an imperative for sustainable development. Second, that law plays a central role in this context. And third, that we as lawyers have a particular responsibility to promote access to justice and the rule of law at the international and national level, and that's SDG 16. The starting point of this symposium is that the natural world is in grave danger, as Judge Brown just explained. Nature, vitals, contributions to people and to the natural environment are deteriorating worldwide at an unprecedented scope and speed in human history. One of the core drivers is climate change. It is not yet the #1 driver. Its impacts on nature and people are rapidly increasing. The 2023 State of the Global Climate Report by the World Meteorological Organization has confirmed that last year, 2023, was the warmest year on record. And this Monday, July 22nd, 2024, was the hottest day ever recorded on Earth. Concentrations of greenhouse gases continue to rise, ocean heat and sea levels have reached record highs, Antarctic sea ice extent observed record lows, key glaciers suffered record losses, and extreme climate conditions exacerbated humanitarian crises, with millions experiencing acute food insecurity and hundreds of thousands displaced from their homes. Climate change is, as the United Nations Secretary General said, like playing Russian roulette with our planet. The window of opportunity to hold warming to the crucial 1.5-degree threshold is rapidly closing. This is an all-in moment, and we must seize it. The alternative is chaos, instability, insecurity, and inequality. A world which will be immeasurably different from the one we know, a world in which complex human systems, including the legal system, may collapse. And while it may or may not impact us who are joining this online symposium today, it most certainly will impact our children and theirs. Taking urgent action on climate change, therefore, is not a sustainable development goal. It is a sustainable development imperative. Second, law has to play a core role in addressing climate change for various reasons. Climate change is a collective action problem caused by a vast number of actions everywhere over a long time. And for this reason, also a vast number of actions is required to mitigate climate change. This cannot happen without creating a level playing field, without the mutual trust and confidence necessary for cooperation, and without equity and justice. Multilateral legal solutions are key because the spatial scope of climate change is global, and the temporal scope of climate change is spanning centuries back in time and literally thousands of years to come. And because the pressure on global justice is unprecedented. Therefore, the United Nations Secretary General noted that climate change has the biggest collective action problem can be seen as an opportunity for multilateralism to prove its value. Law, both national and international law, needs to be fit for purpose. And let's look at the challenge ahead. As Justice Brown said, according to science, urgently addressing climate change as well as biodiversity and nature loss requires a transformation of society, a fundamental system-wide reorganization across technological, economic, and social factors, which needs to happen within the next 10 to 15 years or the critical decade. Law is the governance tool to bring about such change. It has proven to transform societies in the past, and it is our best hope for doing so now. We need an unprecedented rollout of legal tools and incentives to fully decarbonize the economy and our lives, while valuing and protecting nature and human rights. This requires putting in place the necessary regulations and measures across the whole spectrum of law aimed at preventing a rise in global average temperature beyond 1.5 degrees. In international law, the primary legal instrument is the Paris Agreement. It is custom designed to increase climate ambition through iterative cycles. The first cycle starts next year with the submission of the 2025 Nationally Determined Contributions, or NDCs. And from then on, things will come hard and fast. Parties must submit NDCs to the UN every 5 years, and every time they need to progress beyond the previous one to the level of highest possible ambition by every single party. Regular global stock takes on collective progress, taking place always 2 years prior to the next NDC, must inform the preparation of those climate plans. And every other year, every party must report on the implementation and achievement of its NDCs. And these are hard legal obligations which states need to comply with. And the Paris Agreement Implementation and Compliance Committee, which I have the honor to co-chair, is the in-house designated body to follow up if parties don't. But these processes are not the only role of the Paris Agreement. Its global goals, in particular the critical temperature threshold of 1.5 degrees, is spreading their normative impact beyond the UN climate regime and beyond state parties, to businesses and corporations who aim to be Paris-aligned, to subnational actors, cities, communities, yet even universities. How often do we hear references to 1.5 degrees now and to its corresponding pathway of net zero emissions by 2050? But let me be clear, we would not be talking about 1.5 degrees without the Paris Agreement. Even the IPCC would not be talking about 1.5 degrees without the agreement. The normative anchor of a global legal consensus on a tolerable temperature threshold is the Paris Agreement. I often hear critique of the agreement. That's not enough, or it's not fast enough, but we don't know that yet. The processes, as I just explained, are only kicking in motion now, and we have to give it a chance. The agreement is the best we have with the means that we have. And it's my strong belief that we as lawyers have a professional responsibility to understand it and to defend it. But it's not a silver bullet, and it does not answer all the questions. And this brings me to my third and final point, the rule of law and access to justice, SDG 16, in the context of climate change. Climate change is complex. Its causes lead to impacts beyond the climate system, for example, to ocean acidification, and its effects are far-reaching, impacting human rights, terrestrial ecosystems, ocean health, migration, displacement, even trade and investment. Not all this is dealt with in the Paris Agreement. The legal answers to many of these issues have to be found elsewhere, and they are now coming from far-sighted judges at international courts. Since last year, international courts have been involved in defining and clarifying the rule of law in addressing climate change. So has the European Court on Human Rights in Klimaseniorinnen against Switzerland established that states need to put in place the necessary regulations and measures for reaching net neutral greenhouse gas emissions within the next 3 decades, aiming at preventing serious and irreversible adverse effects on human rights due to climate change, and that in the absence of any reference to the environment, let alone to climate change, in the European Convention on Human Rights. And the International Tribunal on the Law of the Sea, in its recent advisory opinion, to which Judge Brown just alluded, has made it crystal clear that anthropogenic greenhouse gas emissions from any source are pollution of the marine environment. And it follows that UNCLOS parties must take all necessary measures with stringent due diligence to prevent, reduce, and control pollution because of the severe consequences by climate change on the marine environment. And such measures may take many forms, including putting a stop on oil, gas, or coal developments, or even to reducing emissions from deforestation, or by protecting and conserving forests. The findings of the European Court on Human Rights and ICLOS draw on the Paris Agreement as an interpretative tool in giving meaning to other international treaties in the context of climate change, treaties that were adopted at the time before climate change became an issue of international legal relevance. Other international courts are still in the middle of their proceedings. The Inter-American Court on Human Rights is expected to announce its advisory opinion before the end of this year, and the oral hearings at the International Court of Justice will start on the 2nd of December this year. These proceedings will contribute to clarifying the international law on climate change and states' obligations to protect the climate system. Especially the expectations to the International Court of Justice are high with respect to the court's ability to fill in the missing pieces of the puzzle of international law with respect to climate change and to weaving together the various parts to a harmonious and coordinated whole. The ICJ as a court with general competence is, of course, in a very different position than courts with a special competence, not only to clarify the law, importantly with respect to the customary norm to prevent significant transboundary harm, but also to address the relationship between different international instruments as well as between treaties and customary law. Such coordinating function is urgently needed in order to assure states of their climate change obligations and to avoid fragmentation, which would undermine and not strengthen the legal framework on climate change. In concluding, we have entered the era of international law on climate change, where we are witnessing a climate proofing of international legal instruments. This is a necessary revitalization of international law, which will have to prove its ability to grow and develop dynamically in order to address contemporary challenges, a task that currently rests on the shoulders of the international judiciary. But it will have repercussions everywhere, to the oil fields in Norway or the Middle East, to the smallest villages in Africa and Asia, and to the vulnerable shores of low-lying islands. Thank you very much.
Thank you very, very much, Judge Kathy-Ann Brown and Professor Christina Voigt, for these truly inspirational and provoking remarks. You've certainly given our community around the world and those who will be hearing these recordings and the videos over the days to come a great deal to consider, offering profound insights into the very largest and most crucial challenges for global sustainability and justice, and the opportunities for our time to still turn things around. You honor the legacy of the Honorable Justice Charles Gonthier, and we deeply, deeply appreciate it.